All right, all right, all right. It looks like we are live. What is going on, BRI-HIVE? It has been quite a while since we have been live streaming. I am super, super happy to be back. For those of you who do not know me, I am Boss Attorney Bri. I am a California licensed attorney where I practice family law and trademark law. And here on YouTube, we like to talk about different celebrity cases, trademark cases, copyright cases, and really whatever kind of case we feel like covering. For those of you that have been following me for a while, you know that I have been missing in action for a while. I definitely did not intend to take a month off, but I literally took a month off of YouTube just trying to get my business in order, which is still getting in order and all of the things. But we are good. We are back. We are back and we're trying to be consistent again. It's still going to be a little hard because holidays are coming up. My birthday's coming up. My fiance's birthday's coming up. And then the holidays are coming up. So I'm going to try my best to be as consistent as possible within these next few months, but hopefully my office will be opening up in December, getting all of those things together. So I can't promise you anything, but I will try my best to be as present as possible. So yes, it's nice to see everyone back here. How is everyone doing? How is everyone doing? Go ahead and drop it in the chat if you're watching live. If you're watching on the replay, go ahead and drop in the comments how you guys are doing. How was your October? I randomly decided to take October off. I did not know I was doing that. I thought it was going to be like 2 weeks, turned into a whole month, but it's okay. How is everyone doing? We have Marianne Williams. Welcome back to the live stream saying good evening. BRI-HIVE emoji that StreamYard does not show us. Marianne is a member of the channel and has sponsored several memberships. So welcome back, Marianne. Nissa, hello. Hi, welcome back to the live stream. We have Nissa saying, love the hair. Thank you so much. It will probably be different next week. I've had this for a couple of weeks now. Jackie says, hello. Hi, how are you? Tanya D, welcome back. Another member and moderator of the channel. Nice to see you here in the live chat today. Editor Danielle Marie says hi. Hello. Welcome to the live stream. We have Kim saying hi. Glad to see you. I'm glad to see you guys too. I was nervous about coming back. I was nervous about coming back. Isabel, thank you for welcoming me back. April Bagshaw says hello. Hi. Welcome. Sage Moon, nice to see you. Saying hi, Bri and BRI-HIVE. Glad to see you. Also glad to see you. Joanne says, a good evening. Hello there. April says, live, or wait, I think it's live. Yes, we're live. Don Chute says, hello from Pittsburgh. Glad you're back. Well, thank you guys for showing up to my re-premiere of being back on YouTube Live. It has definitely been a month for me. Mainly business stuff, getting my health back on track, all of the things, mental health, of course, and just kind of trying to get life together before 2023. So I'm happy that all of you have made it back here, and we're going to be covering some good stuff today. We have Johnny Depp doing an appeal on the infamous defamation case. So we're going to be going a little bit into his appeal. We're not going to be going over anything really with Amber Heard because, you know, we're getting back in the swing of things. Hopefully I know how to work StreamYard still. We're going to be talking about Johnny Depp's appeal. We're not really getting into Amber Heard. I have seen that she has some other things going on, especially like with her insurance cases involving this case, which she is also appealing the verdict against her because she doesn't think that she defamed Johnny Depp. And now Johnny Depp is appealing his verdict that he had against him because he does not think that he defamed Amber Heard through his attorney. I think his name is Adam Waldman. Correct me if I'm wrong with the first name, and we'll see it a little later on. But Waldman saying that he's not responsible for what comes out of Waldman's mouth, right? Third party, no liability, right? So we're going to be talking about that today. April says, love the hair. Thank you so much. Thank you. It's all blonde and brown and A lot of colors. And then Tanya says, make sure you hit the like and subscribe button on the way in. Yes, exactly. See, I don't even have it together, but Tanya got my back. Make sure you guys hit the like button and the subscribe button to support the channel. Jennifer Miller, also another member and moderator of the channel, saying hi, BRI-HIVE. Seeing the like and subscribe. Nice to see you, Jennifer, and thank you so much. Yes, guys, make sure you're hitting the like button and the subscribe button so we can get the channel back rolling. Kim Riley says, I'm driving, so listening. Yes, always stay safe. Yes, thank you for joining in live. I hope it is entertaining. Let's see if I still got it. A little rusty, but we'll get into it. Okay, so let's go ahead and hop into the actual appeal. Like I said, let me know how you guys are doing. Let me know of any cases that have come across the board. I literally avoided YouTube and Twitter and celebrity news like the plague for the last month. So let me know if there are any cases that popped up while I was missing in action that you guys would like for me to cover, even if it might be a little bit old as of today. All right, so let's go ahead and check out the complaint here. Or not the complaint, the appeal here. And so this is in the Court of Appeals of Virginia. I think that this little design here is very interesting. It's very, I want to call it whimsical. It makes me feel like I'm back in the olden times. Like this is the font that they used when they first opened the Court of Virginia. But I think it's interesting. I haven't seen anything like that as far as for a court document. And then so now we have the table of contents. We're going to go over, we're mostly going to go over like the details and the facts and the law part of things. We're not going to go too much into the actual case law and things behind it. So let's take a quick peek into kind of the overarching arguments that Johnny Depp has as far as this appeal goes. So they first are going to argue that the trial court erred in denying Mr. Depp's motion for summary judgment and motion to strike the evidence. So Johnny Depp basically wanted this case thrown out. The jury should have never even heard this part. I'm a little bit on his side with that. I do now. Going all the way back, what was that, April? When did we cover this case? Did it end in like May, at the end of May? Going all the way back then, I did not think that they should have found that Adam Waldman was a third-party speaker for Depp. I don't think they should have found that. But even if they did find it, I don't think that they can find actual malice in Waldman saying those things. So I think that Johnny Depp's appeal is probably gonna go a lot better than Amber Heard's appeal, just off of first instinct. Okay, of course we're gonna look into what he has to say. This is live reaction. I have not read a lot of this, so we're gonna be live reacting to it. Definitely think that he has a better chance than Amber Heard just off of first glance, because I don't think that she should have won this part anyway. So let me know what you guys think in the chat and in the comment section if you're watching on the replay. Okay. And then the reason why they think they aired, the court aired. I don't know. They basically says that Mr. Waldman is an independent contractor. So basically, he could not speak as an agent of Johnny Depp because he is an independent contractor, not an employee. He doesn't have the authority to be an agent of Johnny Depp, is basically what they're arguing. The other part is that Miss Heard, Amber Heard, presented no evidence of Mr. Waldman's actual malice. And that's where I think his strongest point is. Even if they do find that he's not an independent contractor or that he's an agent of Johnny Depp, because technically he is his attorney and attorneys speak on behalf of their clients. So I could see why they would say, okay, he had the authority to speak on behalf of Johnny Depp. But there's also some other case law that may indicate differently as well. But even if the court says, okay, no, the jury was right in finding that Mr. Waldman was an agent of Johnny Depp, they did not really present any evidence of actual malice, like that he said it because he wanted certain things to come out. I don't think that they have the actual malice part. The next reason why they're saying that the court messed up is because in context, the Waldman statements are not actionable. So basically, what he said, you can't prove the truth or the falsity or whatever it might be, okay? The next reason why he is bringing this appeal is saying that the trial court erred in denying Mr. Depp's proposed jury instruction number 22, 23, 24. I don't remember what that is off of the top of my head, but we will get to it a little further down in this appeal. And reasoning is evidence was presented from which the jury could have found Mr. Waldman was an independent contractor. So basically, I'm going to assume that the instructions were independent contractor instructions, like what an independent contractor is, what an agent is, things like that. But we'll see when we go down there. And then another reason why they are appealing the defamation finding against Johnny Depp is the trial court erred in excluding the full articles containing the Waldman statements. So basically saying that the jury got these statements out of context. They needed to see the whole thing to understand what was being said there. And then more reasoning on that part is the unredacted article provided necessary context. Exactly. So they needed to see everything that was there in order for them to make an accurate decision. We're going to skip the cases because that's all boring mumbo jumbo stuff we're not going to cover. And then I'm going to pop into the comments because I see a couple comments coming in on some cases we might want to take a look at. So let's take a little sidetrack right now and see what you guys are talking about in the chat. April says, thanks for the reminder of the like button. Oh, yep. The like button, make sure to hit it. Messing up. Tiny D says, miss you, Jennifer. Good to see you back. Yes, exactly. We haven't seen me in a while and we haven't seen Jennifer in a while. So we're happy to have you back. Marianne says, it's a must in Virginia. Are we talking about the font, the fancy font? April says, I am not sure if you have covered the Tom Girardi case. That would be a great one. I covered not Tom Girardi, but I did cover Erica Jane. I know she has been dismissed from some of the actions. I don't know exactly which cases she has been dismissed from because, like I said, I have been avoiding all of this like the plague so that I can focus on my business and making sure everything was together on this end. But I will look into it. I did, however, as a California licensed attorney, get an email about California State Bar making some changes because of the Girardi case and the trust accounts that we are required to keep on behalf of our clients when we're holding money from them. So Girardi is stirring some things up for little old California attorneys. That case is stirring some things up. Jennifer Miller says, I missed you too. Stupid health issues had me super low for a while. Well, we are happy that you are feeling better and you are back engaging with the chat. Tony D says, thanks for liking, April. Yes, thank you for everyone that already hit the like button. If you hadn't hit the like button already, go ahead and do it. It helps us out in the algorithm. It brings us more friends. And we like friends, right? Abel says, I just realized that Boss Attorney Bri can be an acronym. BANS. Huh? Can it? I thought it was BAB. I think it's BAB. Editor Danielle Maurice says, Nate the lawyer sued C Boozy. No need to cover, but interesting turn of events for sure. Yes, I want to say I was still online when all of that started coming out. I think I got offline like the week that they filed the complaint. So I have not covered that on this channel, but I know a lot of the YouTube lawyers have been covering it. So I haven't had a chance to watch any of their content on it. But maybe as things unravel, we will take a look at it. Well, I guess we could cover it. Nate the lawyer is a celebrity in his own right? We got Nate the lawyer, the celebrity lawyer YouTuber, and then we have C Boozy, who, yeah, I had a little bit of beef with them too because they posted a picture of my fiance, and I did not like that. Jennifer says, I tend to agree with you, but appeals are so different and they're harder for me to predict. And the thing is, it's just the judges are reviewing paper. So they're not getting like the emotion of what the trial judge got in court or what the jury got in court. And they're going to look at it more of the letter of the law. And sometimes jury can get the letter of the law wrong. Even though they are the fact finder, they may not apply it the same way as a judge would. And a judge, in my opinion, just looking at it from what I would have chosen as being like legally trained, is I would have said no actual malice here. And if Johnny Depp argues this right and says there was actually no evidence of actual malice, so how could they find actual malice? I think that would be good for his side of the case. Editor Danielle Marie says, I don't understand how this claim about Waldman got in front of the jury. Seems obviously wrong to me. And that's what Johnny Depp is saying. It should not have even made it to the jury. The evidence should not have even made it to the jury. I don't agree with the finding, but I could see how they could say, oh, it's an independent contractor. He was making the statements on behalf of Johnny Depp. Like I said, there are some laws that contradict an attorney being an agent. So I see where the jury was going with this, but I cannot find the actual malice part of it. And I would love to see how his Johnny Depp's attorneys spell it out in this appeal. Tiny D says, I agree. I don't think she should have won on Waldman's claim either. Okay, look, so a lot of us are on the same page. Okay. Abel corrected it and said, I just realized that Boss Attorney Bri has the acronym BABS, an iconic, strong film cartoon character. Oh, okay. I will look into that. Some people do call me that, but I don't know if I'm all the way familiar with Babs. Cats are fancy. I love the name. Saying, yay, you're live. Yes, I'm back. I am back. I'm live and alive. So I am back here YouTubing it up. April says, yeah, over 200 plus cases that has been filed with the bar in over 40 years. What the heck is that? Or is that referring to Girardi? Yeah. And I think they're going to have to look into some of these bar officials if those bar officials are still working for the bar, because Tom Girardi has been an attorney for a really long time. So a lot of those people might have moved on out of the bar association. Jennifer Miller says, Boozy blocked all of us. Yes, we are all blocked by Boozy Gang. If you even had any association with any of the YouTube lawyers that he knew about, you were blocked. It took a while for me to get blocked too, and I think me and Alita got blocked on the same day. Don Chu says, yep, he blocked everyone. He sure did. Okay, that was good. Good catching up. All right, so pretty much most of the cases, I popped in on Twitter every now and then I also popped up on YouTube every now and then. And so I'm subscribed to a lot of the YouTube lawyer channels. So some of their content did pop up. I just did not click on it in the past month because I felt so guilty for not putting my own content out there. So I'll probably catch up on them a little later on. Okay, let's see what is going on here. So, statement of the case. This appeal arises from a 6-week jury trial on competing claims for defamation, with Johnny Depp and Amber Heard defamed him by implying an op-ed in Washington Post that he had abused her during their relationship and brief marriage. By counterclaim, Ms. Heard alleged that one of Depp's attorney, non-party to the case, that is important to note, defamed her in 3 statements, collectively called Waldman statements, to the United Kingdom tabloid, the Daily Mail, claiming that Ms. Heard's claims of abuse were false. She alleged that Mr. Depp was vicariously liable for his attorney's statements. Basically, Johnny Depp is at fault because he hired Waldman, who was just trying to speak for and defend his client. Mr. Depp filed a motion for summary judgment on the single count counterclaim. The trial court denied Mr. Depp's motion. The case was tried from April 11, 2022 to May 27, 2022. This year has went by so fast, like crazy fast. On May 24, 2022, at the end of Ms. Heard's case, Mr. Depp made a motion to strike her claims, which was denied, and Mr. Depp renewed such motion on May 26, 2022, which was also denied. The jury retired to deliberate. Okay, they had returned a verdict which overwhelmingly favored Mr. Depp. The jury found that Mr. Heard defamed Mr. Depp in the op-ed and awarded Mr. Depp $10 million in compensatory and $5 million in punitive damages. On the counterclaim, the jury found in Mr. Depp's favor on 2 of 3 of Waldman's statements, but in favor of Ms. Heard on the 3rd Waldman statement. That is the only statement at issue in this appeal. On June 24, 2022, the trial court entered judgment on jury's verdict. Mr. Depp timely noted his appeal. Okay, so they let us know why we're in front of the court, what happened in the lower court. A good refresher for us, because this has been a while ago, even though this year has been going by really, really fast. I feel like it was just January and then May, and then now we are in November. Like the year is almost over. So that was a good brief reintroduction or review of what had previously happened. So that was good. Okay. The jury's empathetic, favorable verdict on all 3 defamatory statements alleged in the complaint fully vindicated Mr. Depp and restored his reputation. Indeed, Mr. Depp prevailed in the trial on virtually all material issues, and the verdict of the jury and judgment of the trial court represent an intelligent and well-reasoned decision on the merits after full and fair trial and should be largely, though not entirely, affirmed. However, the trial court was confronted with a number of novel and complex legal and factual issues, and although the trial court decided the vast majority of those issues sensibly and correctly, a few rulings were erroneous. So they're basically saying the judge did a good job on Johnny's side of the case, but as far as this Amber stuff and Amber winning and the Waldman statements getting in, they did not do a good job on that. So Johnny Depp was not fully vindicated because they found liability against him when they should not have found that. Interesting. That's a good one, because you don't want to say that the court was just horrible, because then it's like, okay, well, then maybe you shouldn't have won either. But they're doing a good job as like saucing them up of saying, no, they did a good job, but they messed up a few times and it wasn't on our side. It was just on her side. Okay. Mr. Depp does not appeal the verdict on his claim. No, they did right on his side, right? Nor does he appeal the verdict in his favor on 2 of the 3 Waldman statements, and not on those other ones. They did it right on the other Waldman statements, but they did wrong on this one. So the jury, basically, they're saying they messed up on one thing. His appeal relates solely to the Waldman statement on which Ms. Heard prevailed, and a statement in Daily Mail article April 27, 2022. The judgment in Ms. Heard's favor on the loan statement is erroneous. Ms. Heard's claim was fatally flawed, and the trial court should have granted Mr. Depp's motion for a summary judgment and his motion to strike the evidence for 3 reasons. First, Mr. Depp cannot be held liable for Mr. Waldman's statement as a matter of law. Ms. Heard sought to hold Mr. Depp liable for the April 27 Waldman statement on a pure theory of vicarious liability, contending that Mr. Depp was liable merely because Mr. Waldman had been retained by Mr. Depp as his attorney and was therefore his agent, which is also a good argument for Johnny Depp, because just because that is your attorney does not mean everything that he is saying is on behalf of Johnny Depp. So if he would have been like, Johnny Depp told me to say these things, she might have had a better claim. But him just speaking as an attorney saying that it's fabricated doesn't necessarily, that could be his own opinion. And he's fighting for his client, but he also has his own opinion on the case. So I definitely see where Johnny Depp is going with this. Merely because he retained him as an attorney. But as a matter of law, Mr. Waldman is an independent contractor whose allegedly tortious conduct is not automatically attributable to Mr. Depp. Indeed, a wealth of authority supports limiting a client's liability for allegedly torturous conduct by an attorney, and the court should impose the same limit here. That's what we talked about a little bit earlier. There are laws protecting or saying that your attorney is not your agent merely because you hired them. And we have a super sticker that does not show up here on StreamYard, but it's coming from A Bell, giving us a 149 super sticker with some hearts. You guys that are watching live and on the replay should be able to see the actual super sticker in the chat. Thank you so much for supporting the channel. I definitely appreciate it. All right, A Bell supporting the channel. All right, let's hop back into it. Second, because Ms. Heard proceeded against Mr. Depp at trial on a purely vicarious theory of liability, she was required to present evidence that Mr. Waldman committed each element of the tort of defamation, included that he acted with actual malice. Again, I don't think that they can do the actual malice. He was probably just giving his opinion. No evidence of Mr. Waldman's actual malice was presented at trial, so the judgment against Mr. Depp cannot be sustained. And can Mr. Waldman's intent, can Johnny Depp's intent transfer to Mr. Waldman? Even if he was saying, hey, Amber is a bad person, she's lying, whatever, I forget exactly what the statements were, could that intent transfer from Johnny Depp over to Waldman? Maybe negligently, maybe, but intent, it's hard. Intent is hard to prove. Third, the April 27 Waldman statement viewed in context is a non-actionable statement of opinion insufficient to support a claim of defamation. Remember, for defamation, it has to be a falsity of a fact. It cannot just be your opinion, which I think what Waldman said could probably be classified as an opinion. I don't remember the exact statement off of the top of my head right now, but we'll see a little bit lower when we get there. I think this was the one where they basically said she basically retook pictures or something like that. I have to go and look which one it is. In addition to erroneously denying Mr. Depp's motion for summary judgment and motion to strike, the trial court also erred in excluding from the evidence the complete Daily Mail articles containing the Waldman statements and refusing to give jury instructions as to Mr. Waldman's status as an independent contractor. So that is a lot going on there. Okay. I'm going to hop back in these comments, see what the peeps are saying. Let's see. There was a couple of things that came in. Oh my gosh, we have more gifted memberships. I cannot click on it, but Marianne Williams has gifted 5 Boss Attorney Bri memberships. Thank you so much, Marianne. You are always supporting the channel. Definitely greatly appreciate the support. So 5 people are given memberships by Marianne Williams. We have Divinity Said was gifted a membership. Danielle Lowe was gifted a membership. We have Sage Moon, a moderator of the channel, gifted a membership. Monique and Co. was also gifted a membership, and Cheerful Bacon, I love that name, was also gifted a membership. So thank you so much, Marianne. Make sure you guys say thank you to Marianne. She's always supporting the channel, always gifting memberships over here, and we definitely appreciate the support. Thank you so much. And guys, if you haven't already, go ahead and hit the thumbs up button. It helps us out in the algorithm. It helps us get more friends and more support for the channel. And we have awesome people in here that are already supporting the channels, members of the channels, gifting memberships, doing super stickers. I appreciate it so much. I'm happy. This is a good day back. A good day back. We're in the holiday spirit, gifting, the gifting spirit. So thank you so much. Definitely appreciate it. Dex is the name, says Bri, you're here listening to you commuting home. Yes, nice to see you. Kim says, glad to see you back, Bri. Glad to see you as well. I'm glad to see everyone. I'm happy to be here. Jennifer Miller said it's floating hearts. Yes, for the super sticker, I can see it on Studio. I just can't put it up here on StreamYard. Dax is the name, says woo. Tanya D says, Marianne Williams, you are the best. Yes, Marianne is always supporting the channel. Always supporting the channel. Jennifer says, thank you so much to Marianne. This is so great. Yes, we love to see it. Thank you so much, Marianne. We appreciate you here over at the BRI-HIVE. Yes, yes. And then we have J. Michael RN, a member of the channel, saying, Bri, welcome back. Welcome back as well. We're all welcome back because I've been missing in action, but I'm happy that you guys came back to support the channel. Definitely appreciate it. I was nervous. I was like, what if they forgot about me? But no, it's been great being back. This was a good easing of the mind, making me feel ready to attack some more cases that we've been avoiding for the last month. Okay, let's see what is going on here. Oh, and since I can't pull up the actual gifted memberships, we'll pull up this comment. For the new members, you do have access to badges next to your name now, and then special emojis that, of course, I cannot see here on StreamYard when I pull up your comments, but the chat and the people watching on replay can see it in the chat when you use the special emojis. I also think that I can either add more emojis or badges now because we have quite a few members. And I also did go MIA right when we hit 25 members. So we will probably do the special member stream coming up here soon. Like I said, this month's fiance's birthday, next month's my birthday, and then we got Thanksgiving, Christmas, all of the things. I'm going to try to squeeze it in before the end of the year so that we can give appreciation back to the members of the channel for supporting us, keeping the channel running, really keeping the channel running for us. Okay. Let's see here. All right. Let's pop back over into the case. Assignments of error. They go ahead and say that the trial court erred by denying Mr. Depp's motion for summary judgment as to Ms. Heard's counterclaim and Mr. Depp's motion to strike the evidence as to Ms. Heard's counterclaim, which were the statements by Waldman. Mr. Waldman is an independent contractor, and Mr. Depp is not liable for Mr. Waldman's allegedly tortious conduct as a matter of law. Ms. Heard failed to present any clear and convincing evidence that Mr. Waldman made the counterclaim statements with actual malice. Thus, Waldman's statements are not actionable statements sufficient to support a claim for defamation. And so now, even though they're not attacking they're not bringing up every statement because Johnny Depp did not lose on every statement, they are wanting to kind of include them all so that she doesn't try to bring it back later and says, okay, well, maybe that one wasn't right, but this one is a little bit more actionable. So even though they're not arguing about all of the statements, they are including all of the statements so that the court knows, okay, it's not just this statement, it's all three statements that the trial court messed up on. Okay. They have, they preserved it in all of the documents. Okay, let's see. All right. The trial court erred by refusing Mr. Depp's proposed jury instruction 2022. Every time I see 22, I go 2022. No, that's just the year. Okay. A jury instruction number 22, 23, and 24 as to whether Mr. Waldman was acting as an independent contractor when he made the Waldman statements. They preserved it. The trial court erred in excluding from evidence the full unredacted version of Mr. Depp's exhibits number 881A and 881B and 881C, which are copies of the news articles in which the Waldman statements appeared, instead admitting only redacted versions that showed Waldman's statements out of context. All right. What are Waldman's statements? Because I don't remember exactly what they were. Okay. In connection with the counterclaim, Ms. Heard contended at trial that Mr. Waldman, acting as Mr. Depp's agent, defamed her in 3 statements to the United Kingdom tabloid, the Daily Mail. The first Waldman statement was quoted in the Daily Mail article dated April 8, 2020, and stated that Ms. Heard had used fake sexual violence allegations and promoted, I'm going to call it SV hoax facts. That article also contained a general discussion of the dispute and litigation between Mr. Depp and Ms. Heard, and quotes from attorneys adverse to Mr. Depp. The jury did not find this statement to be defamatory. The second Waldman statement was quoted in a June 24, 2020 Daily Mail article and stated that Ms. Heard allegations were a hoax. That article also included a quote from Ms. Heard's attorney that we believe Amber and we believe in Amber, and a summary that Mr. Depp's and Ms. Heard's sides of the dispute. The jury did not find the statement to be defamatory. The April 27 Waldman statement, the sole statement on which the jury found in Ms. Heard's favor, is contained in Daily Mail article April 27, 2020, with the headline exclusive, I need to report an assault. Listen to a 911 call made the night Johnny Depp and Amber Heard had blowout fight that ended their toxic 18-month marriage, but both claim tape backs up the version. Both claim tapes back tape. Did they write this in the article? Both claim tape backs up their version of events. Okay, I see what they're trying to do there. The April 27 article described a recording of a phone call to the police on the night of May 21, 2016, a date on which Ms. Heard alleged Mr. Depp threw a phone at her and roughed up their apartment at the Eastern Columbia building. Okay, let's see. The April 27 article comments that Heard's attorney says phone records and police department logs vindicate Heard's account of the final shocking episode of domestic violence she endured before filing for divorce, whereas Depp's legal team say this recording does the precise opposite. However, by raising discrepancies in the various accounts Heard and her allies have given on the notorious dust-up. It details Ms. Heard's various allegations about the abuse she claims to have suffered on May 21, 2016, noting that the domestic violence case ultimately fizzled when the two LAPD officers who responded to the 8:27 p.m. call, Melissa Sains and Tyler Hayden, said they never found any evidence of a crime. The April 27 article states that Depp's lawyer Adam Waldman said the various discrepancies proved that nothing Heard and her friends said about the events on May 21, 2016 could be considered credible. It sets out Mr. Waldman's purportedly defamatory statement. And so they go in to say what the full statement was, but in the actual trial, they kind of had this very short sentence of what they're saying was said without giving the full context. So quite simply, this was an ambush, a hoax. They set Mr. Depp up by calling the cops, but the first attempt didn't do the trick. The officers came to the penthouses, thoroughly searched and interviewed, and left after seeing no damage to face or property. So Amber and her friends spilled a little wine and roughed up the place, got their story straight under the direction of a lawyer and publicist, and then placed the second call to 911. Now, I can see why they said that this was a statement of facts, because he's basically saying that since it didn't work with the first call, they did these physical acts as if he knows it for a fact. This is not an opinion, okay? Where they kind of mess up is it's kind of him telling the story in a way that he believed it happened, but he was not there to actually know the true facts of what happened. So it's almost hearsay. It will be hearsay because he wasn't there to know what actually happened. But I guess if Johnny Depp told him the statement, then it will be hearsay from an adverse party, so it could be admitted, but not to prove the truth of the statement, the truth or falsity of the statement. I don't know, Amber Heard. I don't think this is a good one for her. Okay. The April 27 article also includes quotes from Mr. Waldman that Ms. Heard did not include in her defamation claim, but even this didn't have the desired effect because two domestic abuse trained LAPD officers would later provide a pair of sworn depositions saying they saw no evidence of a crime. These lies about who made the calls and when are just the tip of the iceberg, as the evidence will show in court. Finally, it presents a contrary view, quoting Ms. Heard's attorney at the time. Heard's legal team rejected those allegations as fantasies. Mr. Depp's representations about the 911 calls on the night of May 21, 2016 are false, and Mr. Depp and his lawyers should know better, said her attorney, Roberta Kaplan. All of the evidence, including sworn testimony with multiple witnesses, phone records, and police Department logs are consistent with the truthful account given by witness favorable to her. And so that's what her attorneys are saying. So let me pop in here and see what the chat is saying. Let's see. Where are we at? All right, we have April saying, we will never forget about you. I wonder how all you attorneys are able to take this all in. Yeah, it's a lot. It is a lot. And I definitely needed that break, hoping to stay consistent. Tiny D says, we can have a birthday party, Bri. My birthday is next month too. Okay, my birthday is the first weekend, but I'll be gone the first week. So maybe the next week we can have a well, I guess I won't be gone the Thursday before my birthday. So I guess we can have a birthday party stream. Okay. Jennifer says a party stream will be super fun. Yes, I agree. We'll have to set that one up. Mark, welcome back to the live stream, saying, I do remember thinking this was a valid issue not addressed by jury instruction. The employee independent contractor distinction from legal perspective was huge, but not adequately instructed. And that's what Johnny Depp's team is going to argue. Of course, they're going to keep it. They're going to point those things out. And I think that they have some strong arguments, to tell you the truth. I haven't gone through the whole appeal, but I do think they have some strong arguments. Jennifer Miller says, I 100% agree with Mark. April says, be cautious using the SV. YouTube is not kind. They will demonetize the channel, I believe. They usually just demonetize the video, I think. Maybe if you get so many demonetized videos, then they might do the whole channel. June B says the instruction on it were confusing. I don't remember the exact instructions. Jennifer says, I feel like they kind of had to overturn this one. It could open all attorneys to the same thing. Exactly. You can't just say, okay, that's like my clients hiring me and then me getting on YouTube and making a statement about Johnny Depp case, and my client happened to tell me something what they thought about the Johnny Depp case, and then someone sues them for defamation based off of what I said. It didn't really make sense. I guess I would have to relate it to their case. Yeah, that wouldn't make sense because he's just telling the story. He's collecting the facts from his client. So Johnny Depp probably told him, this happened, the cops came, he found nothing. Or even Waldman could have easily just read the police report and saw that they found, or if there was no police report because there was no crime, and found that they found no evidence and could have assumed that, okay, they must have done these things. And maybe he should have used more language like that. We got bots, guys. Moderators, if you can help me out with the bots there. But basically saying that this is distracting me. We got to get rid of the bots. Okay, let's see. Okay, let's see. I don't know if I can get all of them. Are they gone? Not this one. Okay, we had some bots talking about the beautiful girls. It's so weird. But yeah, basically when we present our client's case, our clients can't then be held liable because we're the ones saying it. It doesn't make sense. So I would agree with Jennifer. They're going to have to overturn this because it's going to put too much liability on clients based off of what the attorneys say. And then we're talking about attorney-client privilege. Maybe Johnny Depp did tell him those things, or maybe he didn't tell them those things, but it's Johnny Depp's privilege to say whether Waldman can put that out there. And Waldman did not say, Johnny Depp told me these things. So I don't know. I don't think that Amber has a very strong argument here. April says, let me know if I'm incorrect. I don't know exactly what you're referring to. My brain, like once I go past the chat, it completely disappears. So I don't know exactly what you're referring to. Seven Star says, hi, I missed you here. Hope you are okay. Yes, we are doing great here. We just took a, mental health break, business preparation break, but we're back here live. Nice to see you. Mark says, agree. The fact that he doesn't have independent knowledge of what actually happened suggests it's an opinion about what happened. Yeah, he's basically telling the story based off of the police reports, probably based off of what Amber Heard described in the trial, probably based off of what maybe Johnny Depp told him, probably based off of what the blogs were saying. So he's just retelling the story and making a possible conclusion, not even conclusion, making an assumption about what probably happened, because the police came, said there were no issues, and then they came back and all wine spilled, and there wasn't that before. So he could just be making an assumption, not necessarily what do you call it, stating it as a fact. Jennifer says to April, I think it depends. Honestly, it seems like some channels can say anything and be fine, but others get snapped. Oh yeah, about the demonetizing. Yeah, I try to filter myself, but a lot of times I'm just reading and then it just comes out. Tiny D says, thank you for the reminder, April. Yes, of course. Little lady says, oh, she is going to be mad if she finds out she doesn't get 2 million. Can I tell you guys what I think? I think that, remember in the trial, if you guys remember way back to May, in the trial where the judge sent them to the back room to come up, they forgot to fill out something on the jury sheet. I believe, in my opinion, my thoughts are that the jury did not award Amber Heard any money, and they left that line blank. And that's probably why they sent her back. They could have awarded her something nominal like $1 or zero. They could have also awarded her $0 because they don't think she was actually financially harmed by this or suffered any emotional harm by this. But I think they just, in my opinion, I think they just threw that $2 million on there because Johnny Depp's a millionaire. But I think that's what was missing on the jury instruction. Let me know what you guys thought was missing on the, not the jury instruction, but on the jury verdict sheet. Let me know what y'all thought was missing. That's what I think was missing. And I think they just threw 2 million on there. Okay. Jennifer said, I thought I did, but I did it wrong. Oh, to take away the bots. Mark says, are we subscriber only? No, I don't know how to do that, to tell you the truth. I really don't know how to. Is this how you do it? I don't know how you do it, to tell you the truth. I still haven't figured that part out, how to turn it on subscriber only mode for the chat. And then we have April saying, I think it will be overturned. I think a lot of people are leaning towards you on that one. Tiny D says, no, we are not, Mark. Yeah, no, we're not on subscriber only. I really don't know how to do it. Cats Are Fancy says, oh yeah, I do remember that. Yep, she sent them back to fix something on the jury verdict sheet. I really think they just added that 2 million. Jennifer says, I remember that too, and I thought the same. Yep, that's my opinion. I think they just threw that on there. Cats Are Fancy says, also, good Lord, I can't believe that was in May. It feels like it was yesterday. Yeah, time is going. 2022 is going by fast. I can only imagine how fast 2023 and all the other years are going to go. And I always say this. I feel like when I was a kid, time went by super slow. It took forever to get to like winter break, summer break, things like that. But now it's like, it's crazy fast. And it's like a blink. A day goes by in a blink. Okay. Tiny D says, I think they left it blank, signifying she gets nothing. I wish they gave her $2. They could have given her $2. Maybe they did intend to give her $2, but the judge rounded it up to 2 million. This has to be a mistake, not $2. I'm just kidding. I'm not going to put that out there. Might be held liable for Johnny Depp. Okay, let's see what else is here. And the explanation. Okay, evidence relating to Waldman's statement at trial. Ms. Heard presented no evidence at trial that Mr. Depp was personally involved by directing or making any of the 3 statements. That is kind of what I said earlier, right? Mr. Waldman could have easily just been making an assumption off of things that he made in the blog. There is no indication that Johnny Depp specifically said the police came, because wasn't Johnny Depp gone by that time too? So how would he even know it to be fact or not? And even when Johnny said it, it probably was also an assumption that these things happen. Yes, the way that it's written, it does come off as fact, but if neither one of them was there, there's no way they can say it as fact. It would be hearsay, it would be assumptions, it would be opinion. I think Johnny Depp's attorney is onto something here. And there's nothing that Waldman is saying, Johnny told me this. It also doesn't give his source. Like, I saw this on the blog, and my opinion would be that they did this. He probably could have made it a little bit better by saying what probably happened is that this is a hoax. They probably called it the police when something didn't happen. They went back and probably did these things. If he would have added probably would have been a stronger case for them. But I also think it comes off as opinion. It can't be fact because they were not there to personally witness it. It would be hearsay. Even if Johnny did tell him that, it wouldn't be to prove the truth of the statement actually made, because Johnny was not. If I remember correctly, Johnny was not there when the police came. Okay. Okay. And he didn't tell Waldman, hey, go out there and make these statements. They probably, in their opinion, just thinks that it was a hoax. It was fake. Okay. Indeed, Mr. Depp testified that he had never, ever seen the Waldman statements prior to the filing of the counterclaim in August of 2020. I don't know if that's a very strong argument, because just because you didn't see it doesn't mean you didn't tell him to say it. But if you never heard of it, then that would probably be that would probably have been a better statement for him to put there. Mr. Waldman has a professional license, is the owner and managing member of his own law firm, and provides legal services to his client. Mr. Waldman was retained by Mr. Depp in October 2016 and still represented Mr. Depp at the time of the trial testimony, but Mr. Depp is not his only client. Mr. Waldman's relationship with Mr. Depp is solely one of attorney-client, and he has represented Mr. Depp in various litigation matters, including his litigation against Ms. Heard. Again, maybe Mr. Waldman's other client came in and said, dang, have you heard of the Johnny Depp and Amber Heard situation? This thing is a hoax. The police came, they found nothing. They called him, they spilled some wine, threw some furniture around. The police came back. It could have been a completely different person that told Adam this story, or he could have just made it up himself. It doesn't necessarily mean that it came from Johnny Depp. It could have also been from the actual video that they discovered it, or the blogs or anything. Doesn't necessarily mean it came from Johnny Depp. So I think Johnny Depp's attorneys are doing a good thing by bringing this, because I think that they are onto something. Not onto something. I think that they have a good chance of winning. Okay. Where were we? Mr. Waldman testified that while he believed he had some knowledge of the conduct of Mr. Depp and Ms. Heard, he never personally, here we go, guys, he never personally witnessed any interaction between them prior to his retention in October 2016, which was after their separation. Mr. Waldman testified that he made each of the Waldman statements. Ms. Heard did not present any evidence of whether or why Mr. Waldman believed each of his specific statements. In response to a more general inquiry about Ms. Heard's allegation, however, Mr. Waldman testified at length on why he believed that Ms. Heard's allegation against Mr. Depp were false, describing physical evidence, exactly, seeing the crime, seeing the video, the reports, and identifying multiple witnesses whose testimony he believed contradicted her allegations. Again, his opinion of what likely happened. It's a hoax. Mr. Waldman also testified that he had filed a claim with the Los Angeles Police Department against Ms. Heard for perjury due to her claims that Mr. Depp abused her, and that he presented them with the information to establish her perjury. So it could have just honestly been his honest beliefs about what happened. Okay, we're going to go over, they erred by not doing summary judgment. Their standard of review, we're going to skip over that. They're going to review it de novo. Let's see. We're not going to go through all of this. This is a lot. But as we already talked about, they're going to argue that he was an independent contractor. So we'll read the first page or so. And then let me know if you guys want this document, because it's a lot. Mr. Waldman is an independent contractor. Ms. Heard presented no evidence at trial that Mr. Depp was personally involved in directing or making the Waldman statements. Instead, she chose to pursue a pure vicarious liability claim against Mr. Depp, contending that he was liable for Mr. Waldman's allegedly defamatory statements simply because Mr. Waldman was his attorney. And remember, vicarious liability, you need to be an agent, you need to be an employee. If you're an independent contractor, you decide what work you do and which way you do it and how you do it. When being a lawyer, you're not the employee of your lawyer. You're an independent contractor for them. The client does not direct when you do work. The court does that by giving you a trial date. Most of these lawyers are doing their own work in their office. They have their own supplies. They have their own runners that go to the court and all of those things. So yes, he would be an independent contractor. He would not be an employee. So I definitely understand why they're making this argument. Let's see. Ms. Heard's proposed jury instruction on her counterclaim, which the trial court adopted and gave the jury, were based solely on vicarious liability theory and did not require a finding of any conduct by Mr. Depp in connection with the Waldman statement. That claim fails a threshold issue whether, as a matter of law, Mr. Depp can be held liable for the intentional tort of defamation based solely on statements made by his attorney on pure agency theory. And if I'm not mistaken, law school, because I deal with this on YouTube and back in law school. I do not deal with this on my regular practice. But if I can go back to law school, a person's intentional tort cannot be passed on to the employer unless, even if they did find that he was an employee and that he should be held liable vicariously. You cannot pass the intentional tort of an employee on to the employer. So unless they have previously condoned the behavior or they supported the behavior, let's say you guys hire a landscaper to come do your yard work, and the landscaper gets all mad and decides to punch the owner of the land. Do we then hold the employer responsible for that? Probably not. Probably not. Because you didn't know he was going to punch someone. Maybe this person had a super crisp record. There's no reason to believe that he's going to punch someone over the landscaping. Should we hold employers liable? And now I don't know the full law on this. I could probably look it up a little later on, but I don't think that would transfer over, even if they did find employer responsibility. I should look into that. Okay. In the context of vicarious liability, Virginia has long recognized that the distinction between servant and independent contractor and follows the well-established rule that principal is generally not liable for tortious conduct of an independent contractor. Recognizing in Virginia doctrine, respondent superior, again, going into an employer being responsible for the things that their employees do. Let's see. The theory on which the master is held liable for his service conduct is based on the right of the master, actual or potential, to control that conduct and to see it that the negligent acts which cause injury to others do not occur. And as you see, it says negligent act. You can hold the employer liable if the landscaper forgot to, I don't know, put a safety on a sharp object and they cut someone on accident, negligently. But intentional, let me see what kind of law, let me see if they talk about laws for intentional acts. But an employer cannot control, there's no way you can control someone that decides, you know what, I'm mad, I'm going to punch this person in the face because they're getting on my nerves. I don't think, trying to think back to law school a few years ago, I don't think that the intentional ones can transfer. Okay. I believe Mark is an attorney and says, yes, I think intentional torts can only be held against employer and respondent superior unless the intentional act was instructed or for benefit of employer. Yes, that sounds familiar. I don't know exactly, but that definitely sounds familiar. Because you can't really control someone. I think, if you're a club and you're a bouncer at a club and the employer tells you, okay, if someone's getting rowdy, you throw them out and you break their arm, because you don't want them coming back and trying to fight you, then yes, you can hold the employer liable. But if you just have a random employee that's having a bad day that just decides to punch someone, then no, I don't think you can hold the employer liable. I'm stuck on that. Okay. If the relationship between them does not give the employer that power, then he should not be held responsible for an occurrence over which he had no control. You cannot control what comes out of people's mouth. Johnny Depp was not behind the guy being a ventriloquist and making the words come out, right? In assessing whether a person is an independent contractor, courts consider 4 factors: selection and engagement, which the attorney decides if they're going to work with you or not, and the client also decides. You have to come to an agreement. Payment of compensation. You are paid as an independent contractor. He is not, or he might be, I don't know. He's probably not on Johnny Depp's payroll. Power of dismissal. What do you call it? Johnny Depp can fire the lawyer, and the lawyer can also fire Johnny Depp as his client. And power of control the work of the individual. Johnny Depp cannot control what the attorney does. The attorney is responsible for doing the things with the law, and then the client can be responsible to say, hey, I want this, to be acknowledged, even though it may not be that relevant. But the attorney does have to get permission from the client to do certain things, but on other things, the attorney can act without the permission of the client because it's under his professional responsibility to make sure he's applying or abiding by the laws. Okay. And then the fourth factor, the power to control, is determinative. He can't control Waldman. He can't. Okay. Mr. Depp has not been able to identify any Virginia Supreme Court authorities squarely considered the specific issues, whether an attorney retained in connection with litigation is an independent contractor, and whether the principle limiting liability for contact of an independent contractor applies in the principal agent context, specifically with respect to a current attorney-client relationship. Notably, the Virginia Supreme Court has cited with apparent approval the restatement approach, which limits liability of a principal for the actions of non-servant agents. Okay, so they're going to go into that. We're not going to read that back and forth. But yes, I don't think that they're going to be able to hold Waldman as an employee of Johnny Depp. Even if they do, for sake of argument, find that he is an employee, still don't think they're going to have the actual malice. And that's what we're getting into next. I'm going to check some of the chats to see what y'all are talking about. Let's see. Okay, we covered that one. All right. Dax is the name says, yes, there was a rumor that there was one pro-Amber jury member and that the finding in favor for Amber was an appeasement to this one juror. I didn't know that there was like the juror or whatever, but I did think that they felt bad for Amber. So they was like, she should at least win on something. And then they probably didn't want her to get money, but when the judge sent them back, they probably thought they had to give her something. And if they didn't submit a good amount of money, then they would have got sent back again. I can see that happening. That's my opinion. Don't take it as statement. Jennifer Miller says, exactly. If you weren't there, you don't know. Exactly. Marianne says, or if he said it appears, maybe. Yes. If he would have used a little bit more language, I still think that it can be considered an opinion. They actually found another statement that he made that said this is a hoax for Johnny Depp to not be liable for that one. So I would like to know what the difference in their finding was. It might be what Dax is the name is saying, that it was to appease the pro-Amber juror and so that they can get the heck out of there. I would not be surprised if that's the issue. Is that the best jury conduct? Absolutely not. But could it have happened? It could have happened. But yeah, if he would have used more language, I can see how it's an opinion, or even if Johnny Depp did tell him, the fact that Johnny did tell him that it can't be used to say that this is a fact, I think that also applies here. Jay J Galaxy says Waldman's problem is that one of Amber Heard's witnesses told Adam by phone that it was hoax, but then the witness denied that he ever said that. Yeah, and hey, maybe it was the witness that told him that, not Johnny Depp. Johnny Depp can't control it. He didn't say it, right? I mean, I guess he could say, "Oh, they told you it was a hoax. Get out there and say it was a hoax." But that one's not strong to me. Okay. Mark says, I agree, unless like a corporate counsel attorney should never be considered an employee. Exactly. If he's not like on Johnny Depp's payroll, he's constantly working for him, he works for his entities, things like that, then maybe you can say agency. But just independent contractor, he has all these other celebrity clients. He probably has other attorneys working for him, maybe drafting some of the things for Johnny Depp, maybe without Johnny Depp's permission, but since he runs his own law firm, he can do that, right? All right. I think we covered that one from Mark. April says, have a good night. All got to get up early. Love the great work you do. Thank you so much for joining us live. We appreciate having you here. All right, let's see. We have Don saying, if you are the attorney for a company, then yes, you would be liable, in my opinion. Yes, that is more along the lines of agency, and that is what Johnny Depp's attorney is arguing. Jennifer says, I remember arguing with a guy at work when I was 20. I said some things to my boss that he totally could have gotten me in trouble for. Luckily, I was right, and he saw I was a hot-headed kid. Yeah, exactly. Should the boss be liable? No, we get mad sometimes. Is your job's fault? If it had to do with your job, maybe, but if you're not in the business of punching people, then your employee punching people should not be cause you liability, right? This is says to Jennifer Miller, I deal with those on a daily basis at my job as a therapist. Exactly. All right. So let's see what else is going on for actual malice. Again, this is one of the elements that I feel like Amber Heard did not show. Even if the court were to conclude, even if, we have to make the arguments as attorneys, even though we don't think we're going to make it that far, we have to make the argument just in case it does make it that far. Okay. Even if the court were to conclude that Mr. Depp could be held liable for Mr. Waldman's allegedly tortious conduct, the trial court nonetheless erred by denying Mr. Depp's motion for summary judgment and motion to strike because Ms. Heard failed to present evidence to establish one of the required elements of defamation. Remember, you have to prove every element in order for that defamation claim to go forward. Specifically, Ms. Heard failed to present evidence that Mr. Waldman acted with actual malice when he made the April 27th statement. As noted above, Ms. Heard chose to pursue a theory of vicarious liability against Mr. Depp at trial. She did not ask the jury to find that Mr. Depp was directly involved in making the Waldman statements, nor did she present any evidence that would permit the conclusion. Vicarious liability is liability for the tort of another person. A vicarious claim therefore cannot proceed against an employer or principal absent of showing that the agent or employee committed a tort. They probably cannot show that he was an employee. Okay, let's see. If the agent cannot be held liable, neither can the principal because there is nothing to impute. In this case, since there's no actual malice, then Waldman could not be held liable. Therefore, Johnny Depp cannot be held liable if he was considered the employer. As a natural consequence, it is well settled in Virginia that where master and servant are sued together in tort and the master's liability, if any, is solely dependent on the servant's conduct, a verdict for the servants necessarily exonerates the master. Because a principal cannot be vicarious liable for his agent's tort unless the agent committed all elements, and so they're basically arguing that they cannot prove all elements, which is the actual malice part. I don't think that they can prove actual malice, even if they think that the statement was a statement of fact. Okay, even though I don't think that they can, but even if they do prove that, I don't think they can prove actual malice. Okay. Mr. Depp cannot be vicariously liable for Mr. Waldman's alleged tort unless Ms. Heard carried her burden of proving that Mr. Waldman committed every element of defamation, publication of an actionable statement with the requisite intent. With respect, with respect to the requisite intent, a plaintiff who is a public figure, such as Ms. Heard, must prove that a false and defamatory statement was made with actual malice, subjective knowledge that it is false, and with reckless disregard as to whether it was false or not. All right, they go into the standard of actual malice. We know it's a very high standard to prove, so we're not going to go through all of that. And I think Johnny Depp wins there as well. Okay, so I don't think that they can prove that he was an employee. And then on top of that, I don't that Waldman was an employee. And then I don't think that they can prove actual malice. Okay, another reason why they're saying that this should have gone out of the window on summary judgment, this should have been excluded from evidence, is in context, the Waldman statements are not actionable. Even if the court believed that Mr. Depp could be liable for Mr. Waldman's statement, Ms. Heard's counterclaim for defamation is still fundamentally defective because read in context, the April 27 Waldman statement is not an actionable statement of fact. Like we've been talking about, opinions, assumptions, guesses. Maybe someone told him that wasn't Johnny Depp. Not necessarily facts can't be facts because they did not personally witness it. Okay. The trial court thus erred in not granting Depp's motion for summary judgment and motion to exclude the evidence. Pure expression of opinion, not amounting to fighting words, cannot form the basis of an action for defamation. The First Amendment to the Federal Constitution of Virginia protects the right of people to teach, preach, write, and speak any such opinion, however ill-founded, without inhibition by actions for libel or slander. Conversely, however, there is no constitutional value in false statement of fact. Thus, in an action for defamation, a court must resolve as a threshold matter whether an alleged defamatory statement is one of fact or opinion. A statement of fact is one with provable false connotations and which can reasonably be interpreted as stating actual facts about a person. Again, he was not there, so how could he state actual facts? However, even a provable false statement is not actionable if it is plain that the speaker is expressing a subjective view and interpretation, a theory, conjecture, or surmise, rather than claiming to be in possession of objectable, verifiable facts. There you have it, guys. There you have it, guys. This is him just repeating based off of things he might have observed, but not actually observing the facts. Importantly, in assessing whether allegedly defamatory words are fact or opinion, the court must examine them in context, with the aim being to interpret them as other people would understand them and according to the sense in which they appear to have been used in the totality of circumstances. And this is why they're basically saying that it should not have been made in front of the jury, because as a matter of law, it's not a fact. It was an opinion. The court should have omitted that, made the trial shorter by omitting that, and just keeping it away from the jury, because sometimes lay people are not going to look at it as much as they should when trying to determine where it was facts. Because remember, like I said earlier, there was a similar statement in which he called something a hoax and made further statement about it that they found was not defamatory, or was not, for whatever reason, they found that it was not defamatory. Could it have been that they were supporting the pro-Amber juror? Maybe. But we don't know because we were not in that room. But there were two statements that were pretty similar, that one was found not to be defamatory and the other one was found to be defamatory. So what is the distinction that the jury had there, right? Thus, in considering whether a statement's audience would understand as a statement of fact or opinion, Courts consider such factor as the forum in which the allegedly defamatory statements were uttered and whether an audience familiar with the forum would expect to hear an opinion. As an attorney, you would expect to hear their opinion because that's about all we got in our profession is an opinion. And the facts that the clients give us, and we have to prove that these are the right facts, not the wrong facts. And again, our opinions of whether our client is telling the truth is again opinions because we were not there. We can only go off of what our client is telling us or what witnesses told us, right? Okay. Let's see. The opinion. If a statement is made in a forum in which a reader would likely to recognize that the critiques represent the highly subjective opinions of the author, highly subjective, right? And relates to inherently ambiguous subject matter about which reasonable minds could draw different conclusions, then the general context in which the statements were made negates the impression that imply false assertion of facts. Again, we're talking about it's a hoax. In my opinion, it's a hoax. Does someone need to say, in my opinion, it's a hoax in order for people to understand it's an opinion? Johnny Depp's attorney are arguing that no, you don't need to say, in my opinion, it's a hoax. I think it's a hoax. It's probably a hoax for people to understand that this is Waldman's opinion. So we're going to speed right past some more of those arguments. I think we got enough out of that. And we're jumping into the next part of it. Let me see what the peeps are saying here in the chat. Cats are fancy says mobile chat is a challenge. I feel your pain. It's over something happening. Oh, okay. But they are clients. My phone, sorry. It's okay. It's okay. Things happen. Okay. Mark says, for the chat, master/servant was prior language for employer-employee. It's distinction between independent contractor versus employee. Yes, thank you for explaining that because I sure did not explain it because my law school mind was just like, okay, yep, that's what they're calling it. But yes, exactly. They're just interchanging the words for employer-employee. Master and servant is no longer appropriate for obvious reasons. They have to pay people now, right? Yeah, well, we won't go into that. Cats are fancy says, thanks, Mark. That wording seemed a little sus, but thanks for helping it clear up. And remember, Virginia, let me not talk. Virginia was one of the first states. The colonies, I'm sorry. I want to say. Not a history major. Okay. Jennifer Miller says, thank you for the reminder, Mark. Some of the language is so outdated. Yes, exactly. Jennifer says, I wonder if they were just so over it they didn't pay close enough attention to the details of the claim. I think so, because they had to go through all the stuff with Johnny Depp. It was a 6-week trial. That's a long time to be listening to these people, not to be mean, but whine and complain about things that the jury was not there to witness. So we have to listen to what these people are saying. So I do, in my honest opinion, I do think that Amber's win was a petty win. I don't think they found it because I'll have to look up what the other statement were. But there were 2 statements that were very similar that they said was not defamatory, and then this one was. Okay. Cats are fancy. To be honest, I wouldn't blame them. After the rebuttal of the rebuttal, I would have wanted it to end. The rebuttal of the rebuttal of the rebuttal. Right. That thing lasted entirely too long. And the judge tried to tell them to speed it up on several occasions. All right. I am not used to talking this much anymore. Okay, let's see the next part. The trial court erred by denying Mr. Depp's proposed jury instruction 22, 23, 24. Jury instruction, abuse of discretion. Whether the content of the instruction is accurate statement, relevant principle of law. If proffered instructions find any support in credible evidence, its refusal is reversible by error. Okay, going on to the arguments. Evidence was presented from which the jury could have found that Mr. Waldman was an independent contractor. At trial, Mr. Depp proposed jury instruction 22. An independent contractor is a person who is engaged to produce a specific result, but who is not subject to the control of the employer principal as to the way he brings about the result. If you find that Mr. Waldman was acting on Mr. Depp's behalf but was not subject to Mr. Depp's control as to the manner, method, and or means by which Mr. Waldman worked, you must find that Mr. Waldman was an independent contractor. I think that was a good instruction that should have been included. Number 23, an outside lawyer retained by a client in connection with litigation is an independent contractor. I agree with the statement. I think that it could be basically deciding the fact for the client if you would have included that as a jury instruction, honestly, because you're basically telling them like he was an outside lawyer, so he's an independent contractor. So I would have probably, even though it's true, I probably would have omitted number 23. Just to prevent any bias, I guess I would say. I don't know. And 24, a person who hires an independent contractor is not liable for the independent contractor's action. If you find that Mr. Waldman was an independent contractor of Mr. Depp instead of an employee, you may not find that Mr. Depp is liable for Waldman's conduct, which they did on the other ones. But I agree with that one as well. Mr. Depp incorporates by this reference and will not repeat at length the arguments set forth above Mr. Waldman's status as an independent contractor. In sum, since the evidence supports a finding that Mr. Waldman was an independent contractor, his allegedly tortious conduct cannot be imputed to Mr. Depp absent the evidence of additional involvement by Mr. Depp in making defamatory statements, which was not presented at trial. All right. The evidence at trial established that Mr. Waldman represented Mr. Depp solely as an attorney in various litigation matters, but in no other capacity. He was not his everyday lawyer. Okay. As such, the court should adopt the majority position of other jurisdictions that an attorney representing a client in litigation is an independent contractor. I agree with that argument. Let's see. This is not that long, so we can go through the whole thing. Even if the court declines to adopt a pro se rule, evidence was presented from which the jury could reasonably have found that Mr. Waldman was an independent contractor, not subject to his client's control in the detail of his work. For instance, Mr. Waldman testified that he is the owner and manager of his own firm that offers legal services to clients and that Mr. Depp is not his only client. Accordingly, the trial court erred in rejecting jury instruction 22, 23, 24 because a reasonable trier of fact could have concluded based on the evidence that Mr. Waldman was an independent contractor and thus Mr. Depp cannot be vicariously liable for Waldman's statements. I would love to see Amber Heard's response because I do not think that there is any case law that will support what actually was presented for the jury instructions or why this should have been excluded. I don't think that she's going to find any case law, any statutes that says that lawyers are employees of their what do you call it? Employees of their clients, or lawyers, anything they say, even if they're representing them for one case, is a representation of what the client is saying. I don't think that they're going to find anything that says anything similar to that. All right. And then the last thing is the court erred in excluding the full articles containing Waldman's statement. The standard of review is abuse of discretion. The unredacted articles provide necessary context. At trial, Mr. Depp sought to introduce unredacted copies of the 3 Daily Mail articles containing each of the 3 Waldman statements. I can see why they excluded it because of the length of the articles, the length that the jury has already sat through, all of the other evidence that they had to consider. I can see why the judge might have done this. Was it the right move? Probably not, but I see the judge trying to reduce the amount of evidence and having the jury really focus on the actual statements that are at issue. Okay. The trial court excluded the Daily Mail articles as hearsay, admitting only copies that had everything but Waldman's statements redacted. The court's apparent reasoning was that the Daily Mail article was written by reporters, not Waldman, so the context that matters is the context in which Mr. Waldman made statements to the reporters, not the context in which the statements appear in the article. As set forth in Section 4, in assessing whether a statement is actionable for defamation, context is paramount. While the context in which Mr. Waldman made the original statements to the reporter is relevant, the content of the articles are also relevant. For instance, the full article in which Mr. Waldman's statements appeared are relevant to how the reporters and ultimately the readers understood Waldman's statements as presenting one side's interpretation of evidence gathered in a hotly contested litigation. Further, the April 27 article includes additional quotes from Mr. Waldman that put his April 27 statement in context, identifying the evidence that he is interpreting, again, supporting the fact that he was giving his subjective opinion on the facts. So I would agree with them there. Further, the April 27 article includes additional, we already covered that. But even, and one of the statements is, but even this didn't have the desired effect because two domestic abuse trained LAPD officers will later provide a pair of sworn depositions saying they saw no evidence of a crime, which him saying there was no evidence of a crime. So something must have happened in between the time that the second pair of cops came, right? The full article in which the Waldman statement appeared are relevant to assess what, if any, damage Ms. Heard purportedly sustained from them. In assessing whether Ms. Heard suffered any damages from the Waldman statement, the jury should have been able to consider that Waldman's statements were buried at the bottom of salacious tabloid article and surrounded by substantial additional commentary about Mr. Depp and Ms. Heard, little of which was flattering to either of them. The court erred in excluding the article in full context. I can see the argument there. I agree with that. It was probably a lot of mumbo jumbo that those quotes did not really stick out to the readers. I can see that. And then we have the court should reverse the judgment on Ms. Heard's counterclaim as to the April 27 Waldman statement, but should otherwise affirm the judgment in Mr. Depp's favor. Yeah, don't erase my win. Don't erase my win. But go ahead and get rid of her win is basically what they're saying there. Okay, and that is the end. We made it pretty much through the whole document. We didn't read all the words, but it says this brief contains 8,004 words. Who is going to count all of those words? Okay, yes. So what do you guys think of that? Do you think that Johnny Depp has a good chance of winning this? Sorry, that was not a complete sentence. Do you think that Johnny Depp has a chance at winning this? I think that they're putting forward very good arguments. I would love to see what Amber Heard's team comes up with, what they think they're going to be able to show to say, no, the jury got that one right. I don't think they're going to be able to do it. I don't think they're going to be able to do it. Okay. All right, Jennifer Miller says, don't forget to buzz the like and subscribe button. Join us on Tuesdays and Thursdays at 4:30. We are probably going to start pushing it to 5 p.m., guys, because I have to get my work done. So we're probably going to push it to 5 p.m. starting off, but we are doing Tuesdays and Thursdays. Like I said, we might miss some days over the next 2 months because of all the holidays and birthdays that I have coming up. Going on a cruise next week, so we will not be here next Thursday. And then we have Thanksgiving the Thursday after that. I may be able to squeeze something in, but I'm sure you guys will be busy and don't want to hear me talk on Thursday. We might do something on Friday. But yeah, so it'll be a little changes in the schedule over the next 2 months. But yes, normally Tuesdays and Thursdays, and I think I'm going to push it back to 5. Thank you so much, Jennifer, for reminding everyone. Bonnie says, hi, Bri. Hello. Welcome back to the live stream. Legally, Antoine says, where we at? We here. We here. We covering Johnny Depp and we covering, what do you call it? Johnny Depp and Amber Heard. Johnny Depp's appeal. I think it was good. I think it was a good one. Marianne Williams says, yes, better than average chance. I think he is leaning more towards winning on this one. Did we read Amber Heard? I know we read her post-trial motion. Was there another document filed in between that? I don't know if Amber Heard has filed anything else. I'll have to take a look. Tiny D says JD has a good chance of winning. They have strong arguments. I agree with that. Jennifer says 5 p.m. works. Make sure to check the community tab for updates. Yes, exactly. Killing it. We missed you here, Jennifer. We definitely missed you here. June B says Amber Heard has chosen too many issues to appeal. I can't see how they can concentrate adequately on any issues. You mean kind of like how they did in the trial and it was just all over the place and it was not a storyline? I can agree with you there. I think it's going to be hard for them to find enough case law to support her issues. Her thing is that she doesn't want to be liable for anything, when in all honesty she should probably be liable for some things, and maybe she should attack the things that she shouldn't be liable for. Maybe she should be liable for all things, but I don't think she should have appealed. I really don't think she should have appealed. I think if she did not appeal, then Johnny Depp probably would not have appealed. But I don't think she should have appealed. I don't think she's going to have any strong arguments. Marianne says she delayed until the end of the month. As far as which one? Not sure. Are we talking about Amber Heard? I don't know. Mark with a super chat, $5. Thank you so much for supporting the channel. Saying, looking forward to seeing Amber's brief. I've always thought her legal case was better than factual case, but Johnny Depp had a good agency argument. I agree with you there. I think if they would have focused more on the emotional, I think like what was the guy's Rotten Rosen, what was his name? Her male attorney's name. He was trying to focus on the fact that abuse can be emotional, but she kept wanting to go on and on about all of these bruises and attacks that should have technically resulted in more bruises, and it just didn't. Her factual case was not as strong as her illegal case. I definitely agree with you, and thank you so much for supporting the channel with a super chat. Definitely appreciate it. Jennifer says, thank you, Mark. Love the super chats. Yes, of course. Marianne says, Amber Heard got an extension for her appeal. Oh, yeah. Okay. Yeah. I know she had I'm just trying to think if she filed something in between the post-trial motion, because we did go over the post-trial motion a little bit on this channel. Or maybe I just downloaded it and didn't go over it. Rottenborn was his name. Rottenborn. Okay. Yeah. I can remember his name. That's not a good last name, but I cannot remember it. Okay, guys, that is all I have for today. Thank you so much for joining us live. We are back like we never left. And so we will be here again on Thursday. We'll find some cool cases to cover, or I'll try to find a cool case to cover. And I will see you on Thursday. Thank you guys so much for joining. I'm happy I was able to stream without too many hiccups today. I thought I would be all over the place, but I will see you guys on Thursday. Bye.